of, maybe we can advance one slide forward there to tell you that the lab itself aims to strengthen community resilience, which is a method of preventing violent extremism that I should say probably first comes from the first 15 years of my career, where after getting my doctorate right here in Michigan, in Ann Arbor, I went to Germany and studied school-based responses to racism being created by anti-Semitism and other forms of racism and hate. And I thought I was a comparative education professor. I wrote 2 books on that issue. I became an accidental expert. People communicate online to share hate through memes and other forms of kind of rabbit holes. And then when Charlottesville happened here in the US, I started getting asked to explain this in the American context. And that's when I created the lab. So if we could advance the slide. One of the things, I'm not going to go through all of the text here, but just to say we are in a perfect storm in which we have a more favorable environment to enabling harm, so loss of trust in institutions, a kind of crisis of loneliness. We have the most recent data that we have shows that 50% of American men say their online lives are more rewarding than their offline lives. For example, 25% of men under 30 say they don't have a single friend. So we have weak protective factors, a lack of training about what's happening online, and a very quickly evolving threat landscape that keeps moving and that keeps creating new hybrid forms. We can advance that slide as well. But we also know that everyone wants to feel safe, that everyone wants to feel better equipped, parents in particular, with ways to protect their children against online harms. We find that that parents are the most nonpartisan group we work with. They come to the table ready to understand, and that we need resources. And so one of the things we've been doing right here in Michigan is testing a model that Germans have, which is a kind of, it's called a mobile advisory center, a clinic, if you will, that is not unlike an eating disorder clinic or the kind of resource that you might be able to send a kid to if there was an addiction issue or some other kind of problem, except now we have resources for what happens when someone is exhibiting signs of hate or radicalization or exposure to harmful content online. We can advance that. So if you just look at this model, the way the US has approached this is really through very important and essential ways, as we've heard tonight.
Out of the Michigan encampment at U of M, there's been a lot of misinformation about the case and the execution of search warrants and ongoing vandalism, and we would like to hear directly from you what happened.
Yeah, thanks for that totally unexpected question. And I want to say in advance that I cleared this with Noah, and I said, I know I'm going to get asked, but I want to be able to talk about this. I want to be able to give as much of the story as I possibly can about what happened in these cases, but like completely taking over your event and holding hostage. Everything that happened in this case involves anti-Semitism at levels and in areas formally, frankly, that I've not seen before, not experienced as an attorney, certainly not as Attorney General. First of all, I want to clarify how these cases came to my department, because, you know, what was shocking to me were that stories were actually printed in places like The Guardian and then recirculated on places like Stateside, which I really respect Michigan Public Radio. So to hear these inaccurate stories about how these cases came to be reviewed by the Department of Attorney General, I heard it was from the Jewish regents that they forced me to take these cases. I heard it was from Noah, and also from the Jewish caucus because of the money I get from them. I heard it was from Jewish donors. You know how those cases came to my office? Debbie Dingell. Debbie Dingell, I don't know if you know this, not Jewish, but it had to be some sort of Jewish influence. No, it's not unusual for a congressional representative to call up the Department of Attorney General and to call the Attorney General herself and say, I'm really worried about what I see to be criminal activity occurring, and either the local prosecutor is not doing anything about it, or they're not well equipped to do anything about it, but I am scared about what I'm seeing, and I think the AG's office has to take action. And that happens all the time. And we say, okay, we'll take a closer look at it. You know, we have jurisdiction statewide, so we can go any place in the state and do that. But when this was talked about, no one cared that it wasn't like the Jewish, you know, cabal that came and like swept these cases to the Department of Attorney General. It had to be because of the Jews. It was not, it was Debbie Dingell. And again, that's her doing her job, saying, will you please review these cases that seemingly no one else is reviewing. So I think that was something that I was not expecting to see in regard to these cases. We reviewed dozens and dozens and dozens of cases, things that had occurred at the honors convocation and at graduation and outside the art museum and many things. We only charged out of the dozens and dozens of individuals who were brought to our attention as potentially having engaged in illegal activity. We only ended up charging 11 of them. And none of these cases had been reviewed by the local prosecutors. It's not as though someone else had looked at it and said, well, I'm denying charges, and then we said, oh, we're going to authorize. No one had looked at these cases at all. And I want to say this, and I want to make sure that people understand me when I say this. We don't charge people based on their beliefs. We don't charge people based on their cause. We charge people based on their actions, and that action has to be criminal in nature. And that is why we charged these 11 cases. Not all of them were directly related to a particular protest. Some of them were malicious destruction of property cases, or ethnic intimidation, as it was then called, and people have pled guilty to those things. But most of the cases involved the encampment that was there for about 30 days. Last year, you'll remember. And when we talk about the encampment, I think it's important that people know and understand the facts, because you're not going to hear them presented unless I talk about them right now. First of all, it's illegal to have an encampment. Nobody gets to do that, and no one had done that for 30 days in the history of the Diet of the University of Michigan. And I've been at many, many, many big protests during the course of my lifetime in the Diet, including when I went to the school back in the late 80s and early 90s and was engaged in many protests, but never anything involving an encampment. 11 times the fire marshal came to the encampment to say, this is unsafe. They had a generator in there, they had candles, they had wood pallets, they had chicken wire that surrounded the tents, they had no real easements or walkways. And the fire marshal, in his estimate, said that it would only take 4 seconds, once something caught a fire, 4 seconds for the entirety of that encampment to burn to the ground with everyone in it who would never be able to escape because of the chicken wire around it. So he said, this is so dangerous, it will kill everyone there, potentially, and in the surrounding areas, and if you know the area, and many of you do, that's where all the academic buildings are, that's where the libraries are. So 11 times the fire marshal tried to negotiate and get them to set up a new encampment that would be safer. And they said, we'll even permit one for you, because of course this was unpermitted. But no, they refused to leave. And at long last, finally, because of this significant safety hazard, the police came in with a lawful order to ensure that the encampment was dispersed and removed, and so that there would be a sense of safety there. And individuals were given multiple chances to leave. Anyone who did leave didn't get charged with anything, even if they had been there the entirety of those 30 days, got charged with nothing. It was literally just the people that stayed, through tables and chairs at the police, banded together and pushed against the police physically to try to stop them from clearing the encampment. And those people were charged with fairly low-level offenses, probationable offenses, resisting and obstructing a police officer. But in my career, I've never seen anybody be able to treat a police officer that way while they were in the course of executing a legal order and not get charged with anything. They were simply being treated not differently than other people, but treated the exact same as anyone else who engaged in that kind of conduct as it relates to a police officer. So the cases were charged. We presented the evidence to the court. district court, and that included several days of testimony from the fire marshal, from police officers, hours and hours of tape. Everything was captured on videotape. The judge's job at the district court level is really to do two things. One, you set a bond immediately, but number two, you make a decision as to whether or not there is probable cause to bind the case over to trial, to circuit court, to another court. The end. That's your job. But the judge said he would not make a ruling on the evidence of the case. And first he said that the cases had to be adjourned because 3 of those 9 people that were charged in that matter were undergraduates, and he wanted to allow them to graduate. I don't understand why just having the case bound over to trial, nobody was going to jail or prison, why you had to adjourn it several months, but fine, we did not object to that. But then the next thing that happened was a motion to disqualify me as the prosecutor of the case because I was too biased to pursue these cases anymore. The same claim, by the way, that had been made against me by Rashida Tlaib. She wouldn't say why I was biased. I was just biased. Now, let me make sure that people understand what this motion, like how damaging this motion is. In order to disqualify a prosecutor, normally there's got to be one of a couple things. Either you have a financial interest in the case, and I can assure you I did not, or there's a personal relationship, like you know those people, or your family knows those people, or they used to work for you or something. I don't know these people at all who were charged. And we have never in the history of the state, we've never seen a black prosecutor and had a motion to recuse that prosecutor saying that they couldn't be fair if there were any kind of allegations that potentially the defendants were racist. We've never seen a case where a female prosecutor was disqualified from a case saying that she couldn't be fair because there were allegations that the defendants might be sexist in nature. We've never seen a Christian prosecutor sought to be removed from a case saying that they couldn't be fair because there was something that the defendants had said or done that could be deemed to be anti-Christian. And yet the first Jewish Attorney General in the state of Michigan, the motion said, could not be fair to these defendants because they were pro-Palestinian activists. So we had lengthy arguments on this, followed by lengthy briefings on it, and then the judge said they were going to have evidentiary hearings in regard to this matter. Something that I've never seen in my almost 35 years that I have been either a prosecutor or a defense attorney in the state of Michigan. Never seen anything like this before. Then, in addition to that, the Jewish Federation of Greater Ann Arbor filed, sent an email. They put out a public statement basically saying that they found that to be horrifying because it wouldn't be the first time that a prosecutor was ever removed from a case based on their faith or their gender or their race or any factor like that, and they objected to it. They sent it, unfortunately, to the court, which they should not have done. But that happens quite a bit, where you have an outside party who's not a lawyer send something to the court. Generally speaking, the court just says, I'm not going to read this email because I'm not allowed to see this because it might influence me. Or I'm not going to read this letter that was sent to me because I'm not allowed to read it. It might influence me. But instead, what the court said was that he was going to launch an investigation into the Jewish Federation of Greater Ann Arbor. A full-on investigation, something again I've never seen, 35 years. So now we're at a point, right, where the Jewish Attorney General is being investigated, the Jewish Federation is being investigated, everyone is on trial except for the defendants. I'm sorry, I know I'm going really long on this. I promise I'm going to wrap it up. And, this would have meant multiple more court appearances that my staff would have had to make every time they went in there, screamed and yelled at in a circus-like atmosphere and interfering with their ability to do other work. And no end in sight on this case, because the judge seemingly was not going to rule on the actual evidence in the case. You might remember all the times you heard people saying, drop the charges, drop the charges. They didn't say, I want my day in court. They don't say, I want the judge or a jury to review the evidence. They just wanted the charges dropped because they didn't want anybody to see the evidence, nor did the judge intend to rule on the evidence. And so after reviewing the situation and understanding that all of these defendants would be receiving probation, these weren't murder cases, they weren't sexual assault cases, they weren't domestic terrorism cases, they were probationary cases. And the fact that it was significantly impacting the work of our office, significantly impacting my work. My staff had to start canceling events because every event I did, even job fairs at the law school, were being interrupted and shut down by the protesters. That at long last, we simply had to make a decision as to what to do with those cases. And so we elected that rather than me being put on trial for being a Jewish prosecutor, and rather than having the Federation be put on trial for sending an email they should not have sent, but that get sent all the time, that we would dismiss the charges against those particular defendants. Now, hear me when I say this. There are other cases that have been brought up in the context of all of this that involve, I hate to use the word vandalism because it trivializes when you have F Israel spray painted on the Jewish Federation of Detroit, or you have elected officials where you have, phrases like "I hope you die" spray painted, or other, upside down triangles, which are generally a symbol of I'm going to attack or kill people who live at this house, that are spray painted on your car or on your home, windows broken into in your house, canisters of noxious fumes and chemicals thrown into your window in the middle of the night. Hear me when I say that I intend to vigorously pursue charges in those very serious cases. And if there is another attempt to remove me from the cases because a Jewish prosecutor can't possibly be fair in prosecuting criminal conduct, then I am willing to fight, and I will take it all the way to the Supreme Court if I have to. In which these other cases were dismissed. It's not because I did not truly believe that these individuals were guilty of the crimes they were charged with. And by the way, that's not bias. I hope that every prosecutor who charges a case really thinks the people are guilty when they charge it. I'm not a judge. I'm not expected to be a neutral party. I'm an advocate on behalf of crime victims, on behalf of the people, on behalf of public safety. But that is what occurred in regard to those particular cases, but that is not a signal, nor should it be, that I don't intend to be a tenacious advocate on behalf of law and order, on behalf of justice, and on behalf of pursuing crimes that are committed against this community and all communities in this state for the rest of my time in office.
I want to add one thing, if I may. Has anyone in here heard about the dual loyalty trope? Raise your hand if you've heard of dual loyalty, what that means. So dual loyalty is essentially a very old anti-Semitic trope which argues that Jews are more loyal to themselves and in modern times more loyal to Israel, the state of Israel, than to the nation in which they live. I think of the Dreyfus affair in France. Anyone hear of that? But basically, it is the idea that Jews are always of two masters to their own people versus the country in which they are citizens of. And back in the early 1800s and late 1700s, when we were just sort of emerging as a country, we actually had, even though we had religious freedom in the Constitution, it did not extend to public offices. And so there were in multiple states religious tests, where in the state of New York in the early 1800s, and actually until quite later on, a Jew, a Mohammedan as they used to be called back in the day, but Muslims could not hold public office in the United States. There was a religious test. And actually certain like Catholics couldn't either, right? So what has happened to the Attorney General is another form of dual loyalty, arguing that she is more loyal to Israel, more loyal to her as a Jew, than to the public oath that she took. And I find that reprehensible. It is intolerable. And she's right, it didn't happen to anyone else, but just her as the first Jewish statewide elected official. So I think it's horrendous, and I commend you for dealing with it as you have. So thank you for advocating on all of our behalf.
Yes, thank you for sharing, and I hope that everyone here, after hearing that, if anyone comes to you and asks questions, you can share what AG Nessel has shared with us tonight. Representative Arbit, I would like to ask